candidate secured 2 marks in aptitude test, and my lord, petitioner number 131 secured 5+5.
Yes.
131. My lord, your lordship has the chart. My lord, your lordship will obviously go through this chart. Now, my lord, I come back to the core points. Now, my lord, kindly take আর কি কি জাজমেন্ট বাকি আছে? বাকি নেই না? কোনটা বল? মানে 1 মিনিট। মিড পিরিয়ড বলা হয়ে গেছে 1 2 yes. Well, only one judgment or two judgments. Well, kindly take Om Prakash Chautala's case. Well, the name itself is very tainted. Kindly take.
Yes. Yes.
Kindly take Om Prakash Chautala's case, which your lordship will find. Well, why I am saying this? Page 112. Because my page 112 of the compilation, my respectful submission. Sorry, I am very sorry. 2014 5 SCC 417. I am referring to para 19.
Yes, para 19.
Well, kindly take para 19. It needs no special emphasis to say that a judge is not to be guided by any kind of notion. The decision-making process expects a judge or an adjudicator to apply restraint, ostracize perceptual subjectivity. That is my first, one of my issues which I have raised. Make one's emotions subservient to one's reasoning and think dispassionately. He is expected to be guided by the established norms of judicial process and decorum. A judge may have rhetorics, but the said rhetoric has to be dressed with reason and must be in accord with the legal principles. Otherwise, mere rhetoric, especially in a judgment, may likely to cause prejudice to a person, and the courts are not expected to give any kind of prejudicial remarks against any person, especially so when he is not a party before it. In that context, the rhetoric becomes sans reason and without root. It is likely to blinden the thinking process. A judge is required to remember that humility and respect for temperance and chastity of thought are at the bedrock of opposite expression. In this regard, may be profitably refer to my lord Justice Frankfurter's observation. Well, for the highest, this is what I'm on, for the highest exercise of judicial duty is to subordinate one's personal pulls and one's private views to the law of which we are all guardians, and those impersonal convictions that make our society a civilized community and not the victims of personal rule. As I've indicated, my lord, this was kind of, my lord, perception subjectivity driven inquisitorial process.
Yes.
Along with this, my lord, kindly take, my lord, this similar line, but my lord, this is again page just 1 minute, page 249. This is 343 volume 2, na? Volume 2, 249 volume 2. This is, my lord, the US Supreme Court judgment, where, my lord, Justice Frankfurter again recused from a matter, recused himself. Kindly take paragraph 33, which your lordship will find starting at page 253. Sorry, 343 বললাম তো, 343 US 451, para 33.
Yes.
The judicial
The same principle.
Same
which
principle.
you are arguing.
Absolutely.
Yes.
And my lord, this has been followed by this US Supreme Court has been followed by the by our Supreme Court in 1987 4 SCC 611-238.
Page Which
Yes.
page in the volume?
I'm sorry, my lord, I should have pointed it out. Kindly give me a second. This is page 238. But my lord, kindly allow me to read this one.
Yes. Which paragraph?
My lord, paragraph 20. Or 15 to 20, 25 to 28, but 15 to 20 would be most relevant.
Para 20.
Para 20, this is Justice Frankfurter's
Yes.
observations being quoted. This is again, my lord, on that issue only.
Hmm.
Only paragraph 15 I may add. This is the submission. Only the second limb of the contention is that as to the effect of alleged bias on respondent number on part of respondent number 4. The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and is whether respondent number 4 was likely to be disposed to decide the matter only in a particular way. Malad, there is a concept your lordship has dealt with in so many matters. There is a concept of confirmation bias, which is akin to when witness action is taken. But this principle of confirmation bias is also embedded in our judicial system. And this is what I am on. It is like, my lord, there is a surrounding circumstance that scams are happening everywhere. So this particular recruitment is also tainted with scam. And there is no analysis that there is a distinction between tainted and untainted in the judgment. But these
Yes.
well, these are mainly my submissions. But right, one more judgment. This is on a different footing altogether. kindly take, my lord. This is Srinivas K. Gaura, volume 2, where select list was not challenged. This is not Sadanand Hello. Sadanand Hello, my lord, Mr. Bandopadhyay, my learned advocate general, they have all placed. Kindly take, my lord, Srinivas K. Gaura.
Page.
Page 228. This would be volume 1. Correct. Volume 2. 2022 1 SCC 49. Relevant paragraphs would be paragraph 25, 26. Correct. Kindly take 25 and 25.
Yes.
The division bench of the High Court set aside the appointment of the appellant on 2 grounds. First, the marks provided for candidates at the interview and for experience category were held to be arbitrary. This is like aptitude test. To arrive at this conclusion, the division bench referred to the entire select list and found alleged discrepancies in the allotment of marks for experience and a pattern where all the selected candidates were given higher marks for experience and at the interview. Second, the division bench held that the advertisement issued by the first respondent did not mention the criterion of work experience, but only provided the minimum educational qualification. Thus, it is held that the rules of the game were changed after the process had started. The appointment of the appellant was set aside by the division bench by finding that the additional selection criteria devised and the marks provided in those criteria were arbitrary. As observed earlier, the selection list was not challenged by the respondent. His only ground for challenge was that he had to be selected since he was more meritorious. That is the exact case of the petitioners before lordship. As
challenge the panel.
They have not challenged, my lord. They want to be treated similarly. That is their prayer. Therefore, determining the legality of the selection list and perusing the selection list to determine whether selection of the appellant was arbitrary or erroneous, as the division transgressed the limits of challenge in the writ petition.
Yes.
My lord, one more judgment, that is whether a judgment can be rendered on the basis of conjectures and surmises. This is at page 361, volume 2. প্যারাগ্রাফটা বল 361 বললাম না? Volume 2, 361. I'm giving the citation to my learned friends. 2009, 14 SCC 480, 480, 32.
Para
32, relevant of. Kindly take paragraphs for 32, 46, and 47. I'll take your lordship directly to 46.
para
46, my
46.
46, my lord, at page 370.
Yes.
The manner in which the High Court has dealt with the issue, in our opinion, cannot be appreciated. A court of law must base its decision on appreciation of evidence brought on record by applying the correct legal principles. Surmises and conjectures alone cannot form basis of a judgment. And 47 is on identical lines. So that was dismissed. So, Malad, this is my summons substance. Malad, I would also beseech your lordship. Malad, I do not know, but I am apprehensive that the judgment rendered in the case of SSC matter by Supreme Court may be pressed into service by the others, by my learned friends. Malad, that judgment is distinguishable, and we will make our submissions on that judgment if cited at the time of reply.
Yes.
I'm so grateful, and Malad, I'm extremely sorry to detain your lordships for so long.
Yes. Next, who is coming? Who wants to? Thank you, Mr. Ojumdar. Yes.
Item number 48.
Give the number of the appeal.
MAT number 1387 of 2023.
Just a moment. MAT 13.
1387 of 2023. There are 392 appellants.
Yes.
All untrained.
Yes.
And their leave to appeal application was allowed on 4th of September 2023.
Yes.
And I'll be precise, my lord. I'll not take much time, but I'll start with paper books in Malad board's appeal, that is Malad MAT 873. Malad, you will
good
kindly
after-
take the volume 1.
You said you all are untrained. Everybody is untrained. Do I
Yes,
got?
Malad, I am just untrained general, right? আমাদের
Yeah.
কোনো reserve feather নেই।
Yes.
They all are untrained. Malad, you will kindly keep it in mind, Malad, these entire Malad cancellations of Malad selection process relates to untrained candidates.
Yes. Yes.
Now,
So you mentioned untrained, no? So I was in
No,
doubt.
that's-
Anything. Anyway, yes. What do you want to show?
yes, now you will kindly take there was no amendment to the writ petitions, which was originally filed, that remains.
Yes.
No amendment application filed. The what has been Malad stated in the writ petitions, that was only affirmed by the petitioners and took responsibility thereof. Now kindly take the writ petition once, Malad. It's in page, let's say, start from page 1. Kindly take page 36, the paragraph starts.
Yeah.
All right, paragraph 2, I'll be first showing that your petitioners are unemployed, educated youths of West Bengal. They do not have any regular permanent employment in spite of having qualification.
Paragraph 6.
Paragraph 2, page 36 of the paper book.
Hmm. Yes. Yes, Mr.
They do not have, your petitioners have common cause of actions and they have decided to file this case jointly. The petitioners are praying before this court for exemption of the court fees. Then, my lord, documents of the petitions number 1 to 10 and documents of the petitioner number 130 to 140 showing they are TET qualified are being annexed here too and marked with letter P1.
Yes.
Then, my lord, paragraph. So, some of the petitioners, as they have pleaded, are TET qualified as per their own pleadings. কোথায় pleading? As per pleadings, they didn't say that they are all qualified, but in fact, as my junior said, they are all qualified, but they said only 10, 20 of those petitioners were TET qualified. Your petitioners, next paragraph 3. Your petitioner state that on 19th October 2002, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary school. It is needless to state that there were huge irregularity in TET 2012 and several cases were filed.
Yes.
We are not concerned with TET, but they cited it. In spite of irregularity and illegality, 18,000 teachers were recruited and the government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examinations, and in that case, they shall be exempted from paying any fees for the examinations. Now, just pausing for a moment. These, most of the petitioners, they appeared in 2012 recruitment process, were unsuccessful. Then they participated in 2014 TET and 2016 in recruitment process. They became also unsuccessful.
Hmm.
It was not stated. Now kindly take, my lord.
Yes.
Paragraph 4. Your petitioner states that on 12 November 2000, Council for Teachers Education has published a notification such and such, and in that notification, qualification and other procedures for recruitment are prescribed. Now, your petitioner states that on 9th April 2015, Ministry of Human Resource Development, Department of School Education and Literacy Government, extend some relaxations to the state of West Bengal till 31st March 2016 with certain conditions. Now, if you lordship sees annexure P4, it says that this extension was given because the minimum qualifications is TET qualifications and the DLE, the training qualifications. Now, so far as this extension was allowed with respect of that the untrained candidates can be recruited up to 31st March 2000. And they proceeds on the basis. What happened thereafter, I'll show. What the writ petitioner proceeds on the basis March 2016.
No, that they have not said. They have said.
Yes, that is the specific case. Your relaxation,
Relaxation was up to March 2016.
that case was also that up to I'll show next. Special privileges, so they stand on the same footing. They should be given the recruitment.
Right. They
That
are
is-
not saying that appointment is bad because within that period they have not.
That twofold. One is last cut-off date was 31st March 2016. It could not be extended. Then is since the state government, the
But
board
prior
has
to that, this
selection process started in the present case September 2016. The notification came in September 2016.
advertisement came.
Advertisement.
Recruitment rule was of 2nd of March 2016. That is
2016.
prior to 31st March.
Prior to 31st, but the process was started on September 2016. What happened, Malad? This date was subsequently extended